The topic today is very specific, Section 138 of the Negotiable Instrument Act 1881. Now, before I start saying anything about Section 138, हम कहते हैं ना कि ऐसा क्या चीज होता है जिसकी वजह से नेगोशिएबल इंस्ट्रूमेंट एक्ट बिकेम अ वेरी फेमस एक्ट. ट्रस्ट मी, 138 के पहले एवरीवन न्यू इट व्हाट इज नेगोशिएबल इंस्ट्रूमेंट, बट द इम्पैक्ट ऑफ 138, आई एम जस्ट ट्राइंग टू टेल यू व्हाट इज द इम्पैक्ट ऑफ introduction of section 138 has made everyone means lawyers, business, traders, startups, students, that there is one act which is named as the Negotiable Instrument Act. Now you can just imagine the impact of section 138. Now why 138 was a game changer and why it came, just briefing in just 2-3 statements. धंधा करना डेफिनेटली इज नॉट इजी. आप धंधा करते हो, आप मेहनत करते हो. सबसे बड़ा प्रॉब्लम आता है कि जब आप किसी पे भरोसा करते हो और धंधा करते हो, पैसा आता नहीं है. नाउ सिविल मैटर्स वी ऑल नो इट टेक्स टाइम, इट टेक्स जस्ट लॉट ऑफ टाइम. आई मीन टू से समटाइम्स यू डू इट एवरीथिंग व्हाटएवर यू वांट टू डू, यू डू इट वेरी लीगली, प्रोसेसफुली. एट वन फाइन डे व्हेन यू गेट एन ऑर्डर, यू फाइंड दैट इधर वो मर गया है, इधर उसके पास कुछ पैसा बचा नहीं है, और in every steps of civil matters he will file appeal, and definitely that takes around more to 8 to 10 years. And somewhere I think down the line you think is better मैंने केस ही नहीं किया होता. But this is where section 138 it came into as an enactment, and that was the game changer. At least today if someone tells me कि उसमें क्या है, but I'm telling you when it was introduced it was a big game changer. And somewhere around जहाँ पे out of 10 अगर 4 लोग पैसा नहीं देते थे, it came down to 2 and 1. That was the ratio. Now what exactly 138 deals with, मुझे बताने की जरूरत नहीं है, because आप किसी भी कॉमन बिजनेस वालों को पूछोगे ना कि 138 क्या होता है, शायद उनको पता नहीं होगा. बट आप उनको ये पूछो कि चेक बाउंसिंग, बोला हाँ समझ में आ गया. So 138 is equivalent to check bouncing case. That is the popular name of 138. Now why 138 came, what are the relevance of 138, ingredients of 138, how 138 is helping the business in doing a very proactive business and proactive steps. It is a part I will definitely cover in that particular when I'm going with that. Now when 138 came, earlier procedure क्या होता है, कोई भी business वाला क्या करता है, अगर आप dealer हो, आप distributor हो, आप manufacturer हो, आप business वाले हो, payment is the biggest issue. पेमेंट बिगेस्ट इशू क्यों होता है? आप डेफिनेटली अगर आपको मार्केट में काम करना है ना, आपको क्रेडिट देना पड़ता है. क्रेडिट चल रहा था, सब चलता है, but what if the payment is not coming? Civil matter is already there. This is where the government, they applied their mind. They came with this section saying that even though literally if you ask me, section 138 is civil in nature. It is civil. I mean, let me tell you, it is just a recovery part, but it has been given a criminal, you can say, criminal color, criminal flavor. Now, this is where this was one of the most brilliant section which was enacted in such a way that कि पैसा निकालना civil है, but procedure तो आपको criminal जैसे करना है. And the impact was such that now if you go and ask someone कि आप मुझे PDC दोगे, he will think twice, because he knows what are the relevant, what are the laws which will make him suffer if he fails to make the payment. I am just coming to 138. Simple language, 138 बोले तो check bounce case. That's it. For business 138 बहुत हो जाता है. They are not concerned with 139, 140, 141, 142. कोई कंसर्न नहीं है. मुझे 138 मालूम है. जैसे IBC में सबको मालूम है 420 क्या होता है, वैसे अपना ट्रेडिंग में सबको मालूम है 138 क्या होता है. That's it. But right now what I am talking is all about for the lawyers, and I prefer अगर if a trader can also know what exactly 138 is and how it has to be taken into when you do into your account. Law तो 3 ingredients देता है. Law has given 3 ingredients. एक तो चेक का डेट, 15 दिन के पेमेंट नहीं आया, और नोटिस भेजना. Okay, I am just repeating. Check has to be within 3 months. अभी RBI का रूल है that the check is valid only for 3 months. चेक का डेट मान लीजिए आज 7 जनवरी है. It is only valid till Jan to Feb, Feb to March, March to April. That's it. So 7th I am taking March, Jan से Feb, Feb से March, March से April. So 7th April is your last date, last validity of your check. कानून बोलता है कि आप चेक को within limited time डाल दो. Any number of time. आपने 7 तारीख को डाला, बाउंस हुआ, चलेगा. 10 जनवरी को डालो, 12 को डालो, 3 महीने के अंदर आप कितना डालें आपकी इच्छा. That's your right, you do it. One ingredient. Second ingredient, definitely bounce होना ही चाहिए, no doubt, but नोटिस भेजना चाहिए. द लॉ सेज, आई एम जस्ट मेकिंग वेरी सिंपल, पहले तो चेक बाउंस करवा दो आप 3 महीने के अंदर, फिर आप उनको नोटिस भेजो जो मैंडेटरी है. नोटिस आप कब भेजोगे? मान लीजिए 7 जनवरी 2023 का डेट का चेक है, आपने आज प्रेजेंट किया आई एम टेकिंग 2 days फॉर अ बैंक टू व्हाट यू कॉल गेट इट बाउंस्ड और हॉनर हो गया, दिस गुड, बट टेक एन एजम्पशन कि वो बाउंस हो गया. सो 9th of January, राइट? सो 9th of January से within 30 days you have to issue a notice. Mandatory है, I'm telling you, mandatory है. This is the one of the most biggest defense as an accused if I'm taking कि वो within 30 days issue नहीं हुआ है. Now you might be thinking कि 1-2 दिन से क्या होगा. See 138 जो है ना वो technical matter. It's a very whatever I'm talking, I'm just talking more technical now. आपने अगर 31st को भी नोटिस भेजा, it is illegal. So you lose your right to file section 138. So that is the impact of section 138 का notice period, 30 days. That's it. Now comes the second part. आपने notice भेज दिया 10 जनवरी को, right? So you have definitely you had 1 month, but you want to be proactive and you issued a notice within 30 days. That is 9th को present fail हुआ, 10th को आपने notice भेज दिया, and he has received the notice somewhere in the 12th of January. Now within 15 days he has to make the payment. ये जो 15 days का जो time period दिया हुआ है ना, that shows why 138 is civil in nature. Because क्या होता है, now criminal law में nobody says that you issue a notice. कल को अगर आपने ऐसा कुछ कर दिया जो IPC में लागू होता है, there is no mandatory point कि आप notice issue करो, directly FIR होता है और case होता है. But the moment the law says कि you issue a notice and give 15 days, that is where it is civil in nature. It means I am giving you 15 days time, make the payment to me. अब you might be thinking कि 15 days है क्यों? उसमें हम नहीं जाते हैं, बिकॉज लॉ क्या कहता है कि रीजनेबल पीरियड होना चाहिए, एंड लॉ हैव डिसाइडेड दैट 15 डेज इज अ रीजनेबल पीरियड. नाउ द मोमेंट यू नो सी द इंटेंशन ऑफ द लेजिस्लेशन, मैंने आपको 15 दिन दिया है, आप पेमेंट करो. अब होता क्या है कि अगर एक इंसान को नोटिस मिलता है और वो पेमेंट नहीं करता है, व्हाट कम्स फ्रॉम आउट इज गिल्टी माइंड. हम बोलते हैं मेंस रिया क्रिमिनल, गिल्टी माइंड, इंटेंशन, डिसिट टू इंटेंट. यू नो दिस इज वेयर ये जो इंग्रेडिएंट्स है ना, दैट शोज व्हाई इट इज a criminal trial, civil in nature. Then 15 दिन के अंदर पेमेंट नहीं आता है आपका, within 30 days you need to file a case. So just एक date wise I am just telling you, अगर आपको नोट करना है आप कर सकते हैं. 7 जनवरी का चेक था, मैंने 7 को प्रेजेंट किया, 9th को बाउंस होके मेरे पास आया. Just a pause, please take the original bank memo with the rubber stamp. ओके और आप रबर स्टैम्प नहीं लेते हो, ट्राई टू गेट अ रबर स्टैम्प, बिकॉज आजकल बहुत सारी बैंक्स कभी कभी रबर स्टैम्प नहीं लगाता है, नीचे लिख देता है कि दिस इज अ कंप्यूटर जनरेटेड बैंक मेमो, सिग्नेचर डजंट रिक्वायर. बट आई विल प्रीफर यू टेक अ स्टैम्प, बिकॉज व्हेन यू गो टू द कोर्ट एविडेंस एक्ट इज एप्लीकेबल, एंड एविडेंस एक्ट यही बोलता है कि एवरीथिंग हैज टू बी प्रूवन. अभी आप प्रूव कर सकते हो, आई एम नॉट सेइंग दैट, बट आई हैव ऑलवेज गॉन विद दैट लॉजिक. जितना मुझे कम आर्ग्यूमेंट करना पड़े, जितना मुझे कम डिबेट करना पड़े, मेरा केस उतना फास्ट होगा, राइट? मैंने अगर स्टैंप लगाकर कोर्ट में दे दिया ना, आई डोंट हैव टू प्रूव एनीथिंग बियॉन्ड, आई विल नेवर कॉल माय बैंक एज अ विटनेस. बट अगर आप नहीं करते हो और बाजू वाले ने, अक्यूज्ड ने कभी इसको क्वेश्चन क्रॉस क्वेरी कर दिया, यू वेस्ट योर 3-4 डेट्स और 5 डेट्स इन गेटिंग दैट बैंक, कमिंग टू द कोर्ट, गिविंग द विटनेस एंड गोइंग. और 5 डेट बोले तो नाना करके भी 7-8 महीना. सो लेट्स बी प्रोएक्टिव, टेक स्टैम्प. आपने बैंक मेमो ले लिया, नोटिस, उसने पैसा नहीं दिया, 15 दिन में उसने पैसा नहीं दिया. सो मीन्स आपने 12 तारीख को, मान लीजिए आपको 9th को आपको बैंक मिला, आपने 12 तारीख को नोटिस उसको मिल गया. So within 30 days he was supposed to make the 15 days. 12 से 15, 27 पकड़ो, एक बफर पकड़ लो आप, 28 से लेकर एक महीने के अंदर you have to file the case criminal under section 138. इसमें अगर आपको कुछ भी query you let me know. So I'm just closing this section 138. check 3 महीने के अंदर कितना भी बार भी बाउंस करो, just see to it is within. notice issue करो, ensure 15 days के अंदर पेमेंट हो रहा है, नहीं हो रहा है तो within 30 days case file करो. Now I'm just moving ahead to section 139. Now why 138 was taken as a game changer? उसका punishment important है. The punishment is if you are able to prove your case, check का double amount और 2 साल का imprisonment. Now 2 साल 6 महीना भी होता है, 1 महीना भी होता है. It depends on the court. It depends how you argue the matter. It depends आपका case कैसे setup होता है. End of the day, it is a discretion of the court, right? But intent, important और इंटेंट वो नहीं था कि कितने साल का. इंपॉर्टेंट क्या होता है, सी द लेजिस्लेचर इंटेंट. दे वांट योर मनी टू कम फास्ट, दैट्स व्हाई दे गिव डबल द चेक अमाउंट, एंड देन देयर इज अ प्रोविजन फॉर imprisonment. You will not find in any other recovery forum with this particular punishment. There are around 6 to 7 types of recovery part. I'm not dealing with that, but one of it is 138, and 138 out of 7, this is the only provision, only law which says 2 years imprisonment जो भी है, double the check amount. Then 138 आपका होगा. Now why 138 become a game changer? This is more important. Now what has happened is law has said जिसने चेक दिया जिसने बाउंस अक्यूज ने चेक दिया, बाउंस हुआ, मैं कोर्ट के पास चला गया, आई वेंट टू द कोर्ट, कोर्ट सेज इट इज अ प्रिजम्पशन 139, it is a presumption that the check was issued towards the legal debt. Now I am quoting this legal debt, one of the most relevant ingredient in section 138. Most of the defense of the accused will be legal debt. What is the definition of legal debt? I will come, but presumption आता है कि ये legal debt ही था, चेक आपने उसी के लिए इशू किया, बाउंस हुआ है, now it is your burden to prove कि ये legal debt नहीं था. So we as a complainant, aggrieved party, I filed a case, I have informed the court, court will follow the procedure, they will get the verification done from me, summons will be issued. If they feel कि ये legal debt नहीं था, evidence पूरा करवा, trial पूरा करो. And let me tell you, most of the 138, if your drafting is proper, if there is no story made, even if you feel you want to make a story, ensure you have a good capable person to make a story, because story पकड़ा जाता है. But I am assuming everything is factual. Take it from me, out of 10 matters, 7 to 8 matters will be settled because even they know कि मैं इसको कहाँ तक खींचूंगा, right? I am just taking a pause. Accused कौन बनाना है, कैसे बनाना है, उसका ट्रैक रिकॉर्ड कैसे रखना है, what are the procedure to ensure कि वो accused भाग ना जाए. This becomes one of your, as a lawyer, your strategy, as a business, your internal strategy. So right now I just want to discuss for 2-3 minutes कि क्यों ये important है. Just imagine कि आपको चेक मिला है सोल प्रोप्राइटरशिप से, ओके, और बाजू वाले ने जो चेक दिया है वो सोल प्रोप्राइटर है और आपको पता है उसका नाम क्या है. टेक इट एग्जांपल कि वो ललित जैन है, ओके. आपने नोटिस इशू कर दिया, आपने अगर नोटिस मुझे इशू किया खाली मेरे नाम पे, फेयर इनफ. बट मान लीजिए अगर आपने मेरे फर्म के नाम पर ही किया, जैसे कि मेरे फर्म का नाम है ABC एंटरप्राइज और आपने मुझे अक्यूज नहीं बनाया, दैट नोटिस इज नॉट वैलिड. देन सपोज आपने नोटिस भी अच्छा इशू किया, you are not tracking me where I am, ललित जैन. आप केस करोगे, मैं कभी वारंट लूंगा ही नहीं, मैं कभी समन्स लूंगा ही नहीं. 138 फॉर मी, अगर कुछ चीज ऐसी है जो 138 मुझे जो लगता है द बिगेस्ट लूप होल आई कैन से इज देयर इज नो प्रोविजन फॉर एक्स पार्टी प्रोसीडिंग्स. इट मींस अक्यूज्ड को कोर्ट में आना ही पड़ेगा. अगर वो नहीं आता है, you have to do everything to find where is the accused. That's it. Either this will take a year, 2 year, 3 year, 4 year, but accused have to come to the court to proceed with section 138 matter. आप सोचिए, I am trying to say कि you need to keep a track of your person. आप ट्रैक कैसे रखोगे? अगर वो प्राइवेट लिमिटेड है, पब्लिक लिमिटेड है, LLP है, OPC है, ट्रस्ट है, NGO है, रजिस्टर्ड, इसका ट्रैक आप रख सकते हो इफ यू हैव अ ट्रिगर डेज ऑफ 65 डेज, 90 डेज, 180 डेज. आप एमसी की वेबसाइट पे अगर आप जाते हो तो आपको सब मालूम पड़ जाएगा कि ये कंपनी क्या कर रहा है, फाइलिंग कितना किया. सो आई नॉर्मली प्रिफर कि आप जिसके साथ बिजनेस करते हो ना, हर एवरी मंथ इफ पॉसिबल ट्राई टू फाइंड आउट कि उसने नया लोन कितना लिया, कितने डायरेक्टर्स निकले हैं, कोई नया रिजोल्यूशन उन्होंने अपलोड किया है क्या. इफ यू फील कि ये मेरा सबसे बड़ा रेलेवेंट क्लाइंट है और पैसा इससे कम आता है या टाइम लेंथ में आता है, कीप अ ट्रैक. आप ट्रैक नहीं रखोगे ना, आप 138 प्रोसीजर कर दो, बट इफ द पर्सन इज नॉट कमिंग टू द कोर्ट यू विल गेट स्टक. दिस इज मोर इंपॉर्टेंट, यू नीड टू फाइंड आउट. सी, लॉ ने अपना काम कर दिया है. सेक्शन 138, 139 इज totally in favor of complainant unless and until you do some gucha, but it is totally in your favor. But to make 138 and 139 in your favor, literally in your favor, this is what I say, you need to be proactive. I am using this word, you need to have a pre-litigation strategy. The moment I am using pre-litigation, it doesn't mean कि आप ये मान के चलो कि हर केस कोर्ट में जाएगा. No, it means that you have to have a strategy assuming that if I don't file a matter against A but with B or C, I have to use this strategy either of ways, right? So have one strategy कि कोई भी हो, आप 3 ब्रैकेट बना लो आपके कस्टमर्स के. ऐसा कौन सा है जिसको मुझे केस नहीं करना है, जिसके ऊपर करना पड़ेगा, बट योर स्ट्रेटेजी हैज टू बी देयर. नाउ 138 फाइल कर दिया आपने, 139 का प्रोविजन है, 140 का डिफेंस है, देन देयर इज अ सेक्शन ऑफ 141. बट let me tell you something about 138 as of now. बहुत easy हो जाता है. I have seen in the courts जहाँ पे complaint 3 पेज का होता है, and there is a, you know, I don't know for what reason, I have seen that the complaint is not being drafted very clearly, very nicely. ऐसे लगता है जैसे कि 5:30 बजा है 7 तारीख का और मुझे 6:30 बजे केस फाइल करना है, मैंने 1 घंटे में ड्राफ्ट कर दिया, अभी मैं फाइल कर देता हूँ, बाद में देखूंगा. इट इज वेरी बैड. It just doesn't work out. Your complaint, once filed, cannot be amended. I'm not saying it cannot be, it can be. But the moment you try to amend, it has to be taken with the opposite party. Don't try to give any loophole to the accused to delay the matter. So it is always better कि आप अच्छे से drafting करो. Ensure that all the ingredients are there. ऐसा क्या ingredients है कि notice में होना चाहिए और complaint में होना चाहिए? Definitely अलग अलग vary करेगा. मान लीजिए अगर कोई private company है, वो case file करता है, you need to file a board resolution, mandatory, do that. Judgments है जहाँ पे अगर आप फाइल नहीं करते हो तो you can file later. But you know, as a lawyer or as a person, I just don't want to make any assumption or presumption of future. मुझे जो करना है मैं before filing करना चाहता हूँ. I just want to be very clear. Pass a resolution if a private limited or LLP or NGO or trust, you know, or OPC. If you file a case, have a board resolution, appoint someone, file it. Okay. Now let me tell you the biggest worry what I have seen. ज्यादातर कंपनीज या कोई भी है ना, वो किसी भी बंदे को ऑथराइज बना देता है. एंड आई हैव सीन दैट कि जो बंदा आता है मोस्ट ऑफ द टाइम उनका यही काम होता है कि वो कोर्ट्स में आते करते हैं. बट आई हैव सीन दैट दे आर नॉट केपेबल इनफ टू आंसर द क्वेरी. दे आर नॉट इवन अवेयर कि मैटर क्या है. बट लेट मी टेल यू, देयर आर सर्टेन जजमेंट्स और प्रेसिडेंट्स जहाँ पे ये बोलता है दैट इफ द पर्सन इज नॉट इन अ पर्सनल नॉलेज एंड इफ देयर इज अ कॉन्ट्ररी स्टेटमेंट बीइंग मेड, देन इट डज अमाउंट्स टू अ कॉन्ट्ररी स्टेटमेंट व्हिच इज नॉट गुड. So it's better कि जो भी बंदा फाइल कर रहा है, he should be aware of the matter. As a lawyer, I always prefer कि मैं उसको समझा दूं कि मैं क्या ड्राफ्ट कर रहा हूँ. It should not be a postman work. आग बंद किया, साइन किया, आगे बढ़ गया. No, court doesn't work like this. Just see to it that everything has been explained to him. As a lawyer, take all the approval from your clients. For clients, ensure you receive all the drafts from the lawyer and you approve it so that same is being filed so that you are answerable to the management or you yourself. आप ये प्रक्रिया पूरी कर लो, 138 आपका अच्छे से फाइल हो जाएगा, right? So just pausing right now. Important क्या है? Check. Okay. मैं अगर आपको यही बोलता हूँ कि 3 महीने के अंदर प्रेजेंट करो, 7 जनवरी का डेट है, सो द लास्ट डेट हो जाता है 7 अप्रैल, राइट? लॉ बोलता है अब अगर आप 6 अप्रैल को चेक प्रेजेंट करोगे ना और 8 अप्रैल को वो बाउंस हुआ, यू कैन नॉट डू दैट, इट इज इनवैलिड. ओके, सो आप लास्ट दिन तक मत रुकना. गिव 2 days का बफर फॉर द कोर्ट. ओके, बिकॉज मोस्ट ऑफ द लोग क्या करते हैं कि 7 अप्रैल लास्ट डेट है तो 6 को चेक डाल देते हैं और 9 को वो डेमो डिसऑनर होके आता है. दैट इज नॉट वैलिड बिकॉज बैंक टेक्स अराउंड 2 days टू गेट द डिसऑनर डन. कोई मैटर्स में तो बैंक सुबह लेता है और दोपहर को कर देता है. इट इज नॉट इलीगल, इट इज नॉट इनवैलिड, बट इट बिकम्स अ पॉइंट ऑफ डिबेट. द मोर you try to keep your matter for a debate, it is only a problem for you. You might win the matter, I am not saying that, but then you are delaying the matter. Accused क्या करता है पता है आपको 138 में डिले करने के लिए? He will try everything to ensure डिले होगा. Now this is where we need to be very smart. मैं डिले नहीं करने दूंगा. That's it. डिले आप कैसे नहीं करोगे? Put everything in paper, put everything on time. हर चीज बराबर से आप रखो. Evidence should be there, everything should be managed, and just give it to the court. कोई कोर्ट में ये प्रैक्टिस है कि आप एविडेंस उसी दिन फाइल करो. जैसे एमएम कोर्ट्स में there's the practice कि you need to file your complaint and evidence, तभी जाके समन्स इशू होगा. But I have seen some courts they don't prefer this. आपने complaint भी फाइल किया, वेरीफाई करवा दिया, तो without evidence समन्स इशू होता है. Legally if you ask me, evidence is mandatory. Because I have seen nobody takes an objection. जब तक आप object as an accused, if you ask me, you should take an objection because evidence filing is mandatory for issue of summons. But then this is the part of the practice which I'm pretty much sure आपको ये सब पता होना चाहिए. Now we have covered 138. I have tried to tell you कि drafting कितना important है. A good and a clear, transparent and simple language drafting will take away around 70 to 80% of the debate and the argument of the accused. That is the importance of a good drafting. 20% तो होने वाले ही क्रॉस में आ ही जाता है. Now the question comes about, मान लीजिए आप कंपनी के अगेंस्ट में केस कर रहे हैं. This is where it is more important. Section 141, offense by the company. Now this is the biggest, you can say, A+B वाला इशू चल रहा है. Just 2 days back, there was a settled principle by the Supreme Court that if you file a case against a company, the company should be accused number 1, and second, third, fourth are the directors which you feel are the part of this matter, right? There's a settled procedure. I mean, you need to do that. Just ensure that company is one of the accused. Okay. If you don't make the company as an accused, even though you have a good matter, you will lose it at the end. Now, suppose if you don't file, you have made a company as an accused, and you have not made any other director or individual as an accused, you will fail as a matter, because end of the day, your private limited, ya LLP ho, ya OPC ho, they are all just an entity, legal entity. They have nothing to do with your matter. They are just a body which is taken care by accused number 2 or 3 or 4. Just see to it you ensure ये सब हो रहा है. Now, what has happened is that, why I'm telling you this is more important, because when you file a complaint, you need to make a specific coverment about accused number 1, 2, 3, 4. Now, I have seen that there is a very casual, you can say, habit of putting or writing in the complaint like this. Suppose, A has filed a case against Lalit Private Limited. Now, I have seen the casualness, how it is, the way they put in the complaint, that the complainant hereby states that the accused has issued a check, full stop. We are not even bothering to state which accused have issued the check. We are not even bothered to state who is accused number 1. I don't know for what reason. But then this becomes the defense for the accused, that the person is not defined. And one of the ingredients when it comes to the court is specific coverments. This is very important because the Supreme Court law is very clear now. You cannot make all the directors as an accused unless and until they are into day-to-day affairs of the business. I am pretty much sure that most of the person who have read the company law or who are dealing in company law, there might be a query that why then doctrine of indoor management comes into picture. No doubt, there are certain loopholes which you can argue on this, but again, as I said, it's better to avoid all the debate and make everything very clear when you draft. Okay. Now, what has happened just 2 days back is now again the Supreme Court is hearing one matter where they are saying why it is necessary to make company as the accused. I know that is something you might feel why it is going on, but definitely law changes every time. I hope that this law is not changed, but if it is changed, then a new law will come that the company is not mandatory to be made as an accused. Ab direct director ko bana do, because end of the day, whoever has signed the check or day-to-day affairs, they are personally liable. But as on date, definitely Supreme Court is hearing this matter saying that we need to find out if the company has to be made as one of the accused mandatory. Now, this is 141. Now, what has happened is that there was a new provision which has come for interim compensation. 20%. मान लीजिए आपका अगर चेक 5 लाख का है और अगर आपने 5 लाख का केस फाइल किया है अक्यूज्ड के अगेंस्ट में, देयर इज अ प्रोविजन अंडर लॉ कि आप 143A का एक एप्लीकेशन दे दो आफ्टर डेफिनेटली अक्यूज्ड अपीयर्स इन द कोर्ट दैट I am calling for 20% upfront for them to make the payment to me. Well, सुन के बहुत अच्छा लगता है. Let me tell you कि अरे वाह बहुत अच्छी बात है. But then there's a trigger here. You need to be very clear on this part कि आपको 143 कौन से मैटर में लेना है. Now 143 it's fixed that you just need to prove prima facie कि there is a legal debt. So as an accused, there are two options for him. Either he will put everything on record, which definitely might be a defense for him at the trial, or he will not say anything. He will agree to your interim and he will put you in trial and then take a defense. So you need to play very smart when 143A interim has to be placed. It is not like this कि हर मैटर में 143 करो. Don't do that. From legal strategy wise, you need to be very smart when to do, what to do. Okay. अब जो 143 ये करता है, the procedure I am just explaining you, it is very simple. आप कोर्ट में एप्लीकेशन दे दीजिए. Ensure it that it doesn't have any contrary statements to your complaint, and that's it. For an accused to reply, you have a very good chance either to break the defense or not to open the defense. Okay. Now I'm just keeping a pause here. You know why? See, most of the time, accused, they don't reply to your notice. अगर आपने ये notice किया है ना, then you have to think why. Even if they receive the notice, they don't reply within 15 days. They don't make the payment. You know why? Because they might have the defense, but they don't want to open the defense. Because if they open the defense, you might come with something which overcome their defense. So what they do, they don't reply to your notice. They just wait for you. भाई आप केस फाइल कर लो, हम आ जाएंगे, डिफेंस बाद में बताते हैं. So as a complainant, you need to be very smart. That's why I'm telling you, drafting takes away your 80% of your debate. You need to be very smart in drafting. I'm not, don't try to use like the big words. Be very clear. Use very simple words. That's it. In fact, in one of the Kerala High Court judgment, they have made it You don't have to even mention the reason why you are asking for demand money. Make it very clear. आपने चेक दिया, चेक बाउंस किया, ये बैंक से बाउंस हुआ, आप 15 दिन में पेमेंट दे दीजिए, and you are done with it. But if you really feel that you need to put everything, put it. But just see to it that your story doesn't goes contrary to your story when you file a complaint. We take that part, because 143 actually is the way for an accused and against you also. So this was one of the provision when it started, and it is doing very well. For again, if you ask me legally, it definitely delays the matter, because in fact I'll prefer मैं 143 नहीं करके evidence complete करूँ. But then every matter has its own way. You need to be very smart where 143 has to make an. Well, आपने 143 कर दिया. ट्रायल प्रोसीजर ऐसे ही होता है कि आप एज एन अक्यूज्ड, आपको जब समन्स मिलता है, वारंट मिलता है, यू गो, यू गिव योर पीआर बॉन्ड, श्योरिटी देना है एज पर द डायरेक्शंस ऑफ द कोर्ट. अगर आपको लड़ना ही है, आपको लगता है आपका केस अच्छा है, इज बेटर यू जस्ट एज एन अक्यूज यू अपीयर इन द कोर्ट एट द टाइम ऑफ समन्स, स्टार्ट द ट्रायल, फिनिश इट ऑफ. डोंट डिले द मैटर फॉर नो रीजंस. इफ यू रियली फील you are a real accused, play smart. I don't want to say everything and anything on this platform, but just play smart. Whatever you do, I'm leaving it to you. Okay, now everything said and done. आपका ट्रायल भी वैसे ही होगा, that उन्होंने एविडेंस फाइल कर दिया, उनको एग्जिबिट्स कराना पड़ेगा. जस्ट एज एन अक्यूज्ड बी अलर्ट what they are getting the documents as an exhibit. But for the complainant, take double effort to find out that everything has been exhibited. Everything. I will just share a small story what has happened in one of the recent matters. There was a matter going in one of the court, okay, and there was a paper filed by one of junior person. Now, it just happened that the senior was under an impression that everything has been taken on record. At the time of, argument, it was found that two papers which are original was not exhibited. Just imagine the shock what he received on that day. But definitely you will not show that impression on your face, because you are arguing that matter. Somehow that matter came in favor of accused. But what I'm trying to say, as a complainant or as an accused, just ensure that your documents are being exhibited and it is coming in Roznama. Because if the documents are not exhibited, it will never become a part of your evidence, and at the time of argument, you will lose everything. Okay? Just ensure that. Procedure तो ऐसे ही बोलता है कि complainant will file an evidence, you will take the cross. As per the cross, if you feel you need to get more evidence, you can do that. There is no provision in law for any additional affidavit, mind you. So just ensure that when you file an evidence, it has to be incomplete. You cannot get the loopholes, after the cross. Definitely, certain documents, if they have called upon, you can submit. It should not be a new document. Just see to it, because then it becomes the debate for the accused. Well, the moment you complete the cross, before you informing the court that the cross has been completed and the court passes an order that the cross is over, ensure that you, as an accused, just ensure you have asked all the queries, nothing is pending. Once the court passes an order saying that the cross is over, now then you cannot do anything. You cannot open the account again. It is not a current account or a saving account like a bank. Once the order is passed, it is very difficult to open the cross unless and until you show there was a genuine reason, something ABCD. And remember, even the change of advocate doesn't help, okay? Most of the times I have seen that if you change an advocate, you try to open the cross, it will never happen, because complainant will never allow to do that. So just ensure that you do that. So when the cross is over, the other step, the further step is that the court will take your statement, accused statement, section 1313. We say 313 statement. Now, most of the time people think that 313 is not evidential value. It doesn't have any relevance. ऐसा नहीं है भाई. 313 adds, or it helps the court in finding out what the real nature of the case is. So the accused, as an accused, you need to be very clear what you answer. Whatever you do, that's your personal call between you and your lawyer. But your strategy has to be there very clearly, because once the cross is over, I'm talking for an accused, once the cross is over, and once the complainant, he files a process that I don't want to make any evidence now, prepare your strategy, give answers to the 313 in a manner that you don't have to give evidence. If you feel you need to give an evidence, do in such a manner that your 313 doesn't make any contrary statements to the defense affidavit what you're filing evidence. Okay, 313 आपने कर दिया, right? Then as an accused, you have a chance to file your evidence or not. If you file evidence, complainant will take a cross. If you don't file an evidence, then the matter is kept for the argument. Just imagine, you need to be very smart in what you are doing. Once it is done, argument stage comes, argument has to be done, and then the order will come. Now, what are the ways we can be saved or not. It totally depends on case to case situation, facts of the case. So for an accused, I will say that if you take a cross, ensure that you ask each and every question from the evidence filed by the complainant. For a complainant, just ensure that you prepare your person in such a manner that he doesn't give any contrary statement during the cross. I have seen that the most of the time the complainant, they try to act smart, but trust me, judges are more smart than us because they deal day to day with such cross examination. So it's better not to play smart, be very real to yourself and answer in a manner that answer kya dena hai. Okay, let's not play the game with the court. Be very clear. Prepare a strategy, answer it. But don't play any game because that will only affect your matter. And I have seen that in many matters, and I have seen that most of the time when the complainant, they try to play smart, it goes against them only. Okay. Now 138 is done, 139 is done, 141 is done, everything is done. Now what will happen? Suppose if the accused win the matter, suppose if the matter goes in the favor of accused, complainant, you need to go to the high court. If you're in Bombay, you need to go to the high court, file a leave to appeal, and definitely you file an appeal. As of now, it is taking a good years to come. But for an accused, if you lose, definitely you need to file a revision application. You need to file an appeal before the above court, then the trial court. Suppose if you are in Thane, you need to file in Thane because Thane has two courts. If you file in Vashi right now, you have to go to Thane. So you need to be very clear. Now, mind you, if you file an appeal, you need to pay minimum of 20% as a deposit. It depends on the court. Okay. Suppose if the order is passed in a 5 lakh check case bounce, then you need, suppose if the order is against you, accused, they're saying that you have to pay 5 lakhs, then you have to pay 20% of the 5 lakhs and then get your matter on the board. Definitely it will take time and everything goes as per the process, no doubt. So this is the whole package of 138. Now procedure is not that difficult. Again, I'm telling you, procedure difficult nahi hai. I'll just explain. Check bounce karaiye, within 30 days notice भेजिए. If जिस दिन उनको notice मिलता है, within 15 days they have to make the payment or reply or not, whatever. From the 16th day, within 30 days, file a case. The moment you file a case, summons are issued. If he comes, plea is recorded. If he doesn't come, bailable warrant is issued. If he comes, plea is recorded. If he doesn't come, NBW is issued. If he comes, try to go for a surety and plea recorded. If he doesn't come, then NBW has to be issued to commissioner. If he doesn't come, issue a show cause notice. If he doesn't come, issue a show cause notice again. I'm pretty much sure if the accused is from is a trader or something, he will come down. Okay. If the accused comes, plea record. If he fails to come on a relevant after 3-4 times, try for a surety. Go for a big PR bond or cash bond or whatever. Get the plea record. Nowadays there is a practice which is going on that a lawyer can record the plea. Personally, I feel it is not proper, but then fair enough, unless and until it doesn't affect our matter, go for it. Plea record ho gaya, file. Now, what I have seen is like this, that the complainant, what they do, they don't file evidence. They wait for the accused to come. I am assuming that he will come on next date. I'm just assuming, but I'm not preparing my evidence. They come and then I take a date to file an evidence. I will prefer you don't do that. Keep your evidence ready. Keep everything ready. Keep within your bag. Go to the court. If he comes, file evidence, give the copy. Because what will happen, I'll tell you, in one of the matter what has happened is, accused came, he took the bill. Opposite party, complainant, he took the date for filing an evidence. और आज उसको 6 साल हो गया, he still try to find out where is accused. So don't do that. As the complainant, try to complete everything on time and just give it. Just see to it that every date gives you some result. If the accused comes, if it doesn't come, I am pretty much sure you will take the steps for summons and warrants and everything. आज तो accused को find करना इतना difficult नहीं है. Everything has become online, so try to have everything in your records. Procedure as such यही होता है 138 and everything. Now I want to come to the portion of legal debt. Legal debt ना सबसे बड़ा रहस्य है 138 में. सबसे बड़ा रहस्य है. Because अगर आप देखोगे ना ज़्यादातर if there is any defense which is being made is legal debt. Now the moment I try to tell you what is legal debt, ज्यादातर लोग यही बोलते हैं कि वो legally payable होना चाहिए. Not a bad definition, definitely not a bad definition. But then I just prefer to say something beyond it. Legal debt means a debt in which there was a legal business done. Legal business done. Okay? Nothing illegal about it. Legal business done. And the payment was made. That's it. Now I'm just sharing one example. मान लीजिए आपका इनवॉइस आपने रेज किया था, अक्यूज के लिए बता रहा हूँ, आपने इनवॉइस आपके ऊपर रेज हुआ था 5 लाख का, आपने उनको चेक दिया था 5 लाख का, ठीक है, बीच में आपने उनको पेमेंट कर दिया 3 लाख का, ओके, अभी देखा जाएगा तो लीगली 2 लाख का लीगल डेप्ट है, but this person he goes to the court and he file a case for 5 lakhs. 99.99% plus 99.99% the accused will win the matter, because at the time of filing the case the legal debt was not 5 lakhs but 2 lakhs. Just mind it, legal debt का importance ये होता है that on the date of filing the case or on the date of the check which is bounced, क्या वो debt legal है? If not, केस फाइल करके फायदा नहीं है. दिस इज वन ऑफ द बिगेस्ट डिफरेंस. दैट्स व्हाई यू नीड टू बी वेरी श्योर कि आप क्या क्लेम कर रहे हो, आपने चेक क्यों डाला. देयर आर मेनी ट्रेडर्स, मेनी बिजनेस पर्सन, देयर आर मेनी एमएनसीज, देयर आर मेनी बैंक एनबीएफसीज जो चेक खुद फिल करके डाल देते हैं. लीगली इट इज नॉट इलीगल बिकॉज पैसा उनको बनता है देना है. यू नीड टू प्ले स्मार्ट कि आप कब चेक डालते हो, क्या करते हो, कितना मांगते हो. So legal debt is one of the first feature for an accused to find out कि ये बराबर नहीं था. Complainant, you need to ensure yourself before you make any check or before you try to claim anything, ensure कि ये पैसा उतना pending है. Don't try to include your interest in it as of now, because interest, if it is not a part of invoice, it is debatable. If it is a part of invoice, invoice is a unilateral contract. It is not bilateral contract. So you need to be very clear whether that invoice is valid or has given you the power to claim that interest. I am not saying it is illegal, but it doesn't mean that कि आपने अगर invoice में लिख दिया 36% per annum, it doesn't make you legal or illegal. For me, if you ask me, 36% is not legal. I'm being very clear, and there are many ways how you can protect that matter. Legal debt को define करना बहुत important है. So when you file a case, जब आप notice भेजते हो, use these 3 words. The debt is admitted, undisputed, acknowledged, and hence a legal debt. If possible, use these 3 words. That transaction was done. The debt is duly acknowledged, undisputed, and admitted, and hence a legal debt. 4 words will take away, or as a complainant, it will ensure that you have taken accused in a very good bracket. But before that, just ensure 1138 में legal debt को आप अच्छे से define करना. Please for God's sake, because I have seen many matters जहाँ पे the cases are filed without even thinking of legal debt. Now let me share one scenario. What has happened? कभी-कभी क्या होता है कि this is one of the loophole, let me say, but then law is law. Where there are plus, there are minus. Check was issued for 5 lakhs, invoice were for 5 lakhs, you are not able to make the payment, he issued a notice to you, right? And you have failed to make the payment within 15 days, he filed the case, he has issued a summons to you. Most of the traders, see still in India, we are around 70% as an unorganized market. I'm not trying to say unorganized in a behavioral part or other aspect. The moment I'm trying to say unorganized means most of them are not aware how the law works, how the law proceeds and everything. So my term has to be taken from that perspective. Now what most of the time what happens is that you make the payment, आप payment कर देते हो, but वो case withdraw नहीं करता. Then you have to come to the court, you have to tell the court. What will happen is that आपका 1 साल आपका आना जाना लगता है. You waste your time, you do everything. I mean you do just everything. आपको पता है, कोर्ट को भी शायद बाद में मालूम भी पड़ जाएगा. But just take a pause and do this thing. When you take a cross, ask a query कि पेमेंट मिला था क्या. अगर वो ना बोलता है, in your defense, file the appropriate bank statement, duly stamped and signed, rubber stamp with the bank, saying that कि ये तारीख को पेमेंट हो गया. Do that. But इतना करना ही क्यों है? अगर पैसा मिलता है तो आप विड्रॉ कर लो ना उसी टाइम. Send an email, I made a payment, withdraw the case. आप कर लोगे, this is good for you, will save your money and everything. Now one of the aspect I have seen is that in 138 that the complainant, they always file an application saying that कि accused को बुलाओ कोर्ट में. Well, for a good number of times I was trying to understand why the accused is required when the lawyer is there for the accused. See, this is one of the way how the accused, no doubt, it is law, he has to come, he should come, complainant is coming, but that doesn't make the complainant to file an application every day. As an accused, as a lawyer for an accused, you have to inform the court, I am standing for an accused, I am ready to take the matter forward. Why he wants an accused to come before the court? What is the relevance of him coming? He is only required at the time of 313 and the 3rd defense affidavit. He'll come, he will take the plea, everything is done. So you need to ensure what you are doing, okay? Because I have seen that the applications are being filed that the accused is not present, make an application for warrant. It is not mandatory for them to come every time and every day. Definitely, if you don't appear as a lawyer, if we don't appear, then definitely a warrant has to be issued because the accused is not coming. So that's the whole about 138, legal debt, notice, how to proceed with the matter, what is the procedure, everything. Now I'm just pausing myself. I'm closing my 138 because अगर मैं ऐसे बोलने जाऊंगा तो it is beyond, but I think I have covered every major content of 138, why it came, purpose and everything. Thank you.
You gave an example that the invoice was of 5 lakhs and subsequently 2 lakhs were paid.
3 lakhs were paid.
Okay, 3 lakhs were
Whatever.
paid.
Whatever.
3 lakhs were paid. Now the payment terms are a PDC of say 30 days. Okay. Now PDC has been issued for 5 lakhs and on the first bounce of the check, when it was brought to the notice of the accused, he has paid this 3 lakhs which you are telling. Okay. Now the actual amount remaining is 2 lakhs.
Yes.
He is not paying that amount. So for the second time, the check is being deposited for clearance after informing to the accused. Now there is a recent judgment, as you would be aware, sir, from Justice D.Y. Chandrachud and Hima Kohli, right? So I'm referring to that, wherein they say that the check has to be endorsed on the reverse of the amount which has been paid. Now, after endorsement of this receipt of 3 lakhs, when you are filling that slip, the bank deposit slip, what should be the amount? It should be 5 lakhs or it should be 2 lakhs?
See,
this is not
like,
clear.
See, I'll tell you. Now, definitely you cannot put 2 lakhs because the bank will clear what is the check amount. Okay? So they will not, bank is not concerned with that part कि कितना रुपया आपको लेना है नहीं लेना है. The check contains 5 lakhs. That's it. The moment you go to the bank, they are only concerned. Now suppose अगर accused के बैंक अकाउंट में 3 लाख पड़ा हुआ है, okay? ऐसा तो होगा नहीं कि वो 3 लाख निकालेगा, वो 5 लाख ही निकालने वाला है. 5 लाख नहीं है तो he will get the bounced, dishonor, exceeds arrangement, whatever. हाँ, accused के बैंक अकाउंट में 7 है तो 5 क्लियर हो जाएगा. That's it. Now the question comes, suppose if it is bounced, now whether you can go to the court and file a case. This is what Chandrachud in his judgment stated, that the liability has to be on the date when the check was issued, bounced, on the date. मान लीजिए अगर आपका 5 लाख का था, राइट, आपने उसको फर्स्ट बाउंस किया, आपने नोटिस नहीं भेजा, but he made the payment. He made the payment. Legal debt becomes only 2 lakhs now.
Right.
So my strategy, the way that I feel, either you take that money or get your check swept saying that you give me 2 lakhs. But definitely as a businessman, मैं यही सोचूंगा जो पैसा आ रहा है वो मैं ले लूं, definitely. But then for me you cannot file 138 because then I will take a defense. I made a payment because आपने notice भी issue नहीं किया था. I agree if you have issued a notice and I made the payment within 15 days. I will agree to that.
The case here is the check is first deposited for 5 lakhs. It gets bounced. Then a mail is sent by the seller to the buyer that your check has been bounced. Based on that, the buyer makes a payment of 3 lakhs and he says that remaining will make payment after a few days, which he does not make payment later on.
Then don't reply to such emails. Trust me, it will work in your favor.
Right. Now, once he has replied and he says he has made payment and he's not ready to make payment, now the check is to be deposited again and a check return happens. So doesn't it fall under 138?
Go for it. I'll tell you why. See, it's like this. Law says he has sent an email to you, right? But the moment you reply to an email, we confirm the receipt of email. Now we are waiting for the balance amount. Okay. So now you have agreed to his term saying that I'll make the balance payment of 2 lakhs. So for me, if you go to the court now, I will claim there was no legal debt. I'll claim. But the judgment says then when the check was bounced, the liability was there. But the Indian Contract Act, when it comes with an implied contract, it says if you reply to an email, fair enough, okay, confirmed. It means he made a payment, you had a discussion, now 2 lakhs is pending. So now don't move ahead. So I prefer don't reply to such emails because we have such matters wherein after, the check is because see, आजकल क्या होता है, the moment check is bounced, messages आ जाता है. And very smart people, what they do, they make some payment. We don't reply to them. We file the case. We issued a notice. We don't even refer to that. So when it comes to the court and when they ask such queries, we say आपने किया होता था, but I am not aware. So when we file a defense affidavit, they will put a question कि they will file कि हमने payment किया था. Our question will be जब मैंने चेक बाउंस किया था तभी आपका इतना ही पेंडिंग था ना, आपने कब रिप्लाई किया, कब पेमेंट किया, you show me where I have given the consent to you. Consent is important when it comes to such matters. Consensus ad idiom plays a very big role.
I'm sorry, I'm unable to get to my this thing query resolved. My query is I am the complainant. I have not received that 2 lakhs.
हाँ,
Now I have only this check with me, which is of 5 lakhs.
हाँ,
I endorse on the reverse of it that I have received 3 lakhs,
हाँ,
and I deposit it to the bank.
हाँ.
This check gets returned again.
Definitely it will, because पैसा उतना नहीं
Yeah,
है.
yeah. Now I file a case. Now I send him a notice.
File a case. I'm saying you file a case. Because
I'm sending a notice to him,
हाँ.
and in that notice I claim the net amount.
Now see, it's like this. Now in the notice you are claiming only 2 lakhs.
Yes.
Am I right? You are claiming 2 lakhs.
Yeah, I'm claiming 2 lakhs.
Now, but how you will frame a sentence, I will put. You need, for me it is like this. You need to state like this, that the liability was existing at the time when I bounced the check for 5 lakhs. So when I clear, when the check was bounced, we received some payments. I am not saying what payment. We received some payments. However, the liability is still existing. The check has been bounced. I request you to please make the payment as per the check amount. That's it. Make it very clear. And you file a case. File a case.
Now, if you already mentioned the net amount, does it weaken your case?
See, it's not about weakening. It's all about how you put in trial. Suppose if you have already mentioned it, you file a case, you put in your complaint like this, that when the, right? But the only problem which will come is like this. When you have bounced the check for the first time, he made a payment. And when you have bounced the second time, you knew it, okay, that the payment was for only 2 lakhs. So, if you go legal wise, very, the ingredients of 138. So the second check which was bounced, the legal debt was never in existence. ऐसा होता है.
Then how do we infer Justice Chandrachud's judgment? Because in that he has said that if you endorse on the reverse of the check and then represent the check, then you can file the case under 138. That is what I have inferred.
The way I interpret is not that way, because what will happen is that suppose if bank has a check of 15 lakhs, suppose I have taken a home loan of 15 lakhs, okay, right, and I have given the check of 15 lakhs. Fair enough. Right. Now I have been paying the EMI of around 1 year. So today my home loan is hardly 12 lakhs, right? Right. So if I go by that logic, the bank will deposit the check of 15 lakhs and he will claim 15 lakhs. Whereas when the check was bounced, my legal debt was 12 lakhs.
Right.
That's what I'm trying to say. What is happening is that when he said endorsement, he was trying to explain the manner in which the money can be claimed. But I'm taking that example. Suppose if you have filed a check, you have presented a check, okay, 7th January. Now January ko it get bounced. Fair enough. You have around 30 days time to wait. I mean to say for issuing a notice. Right. 9th January ko, suppose 12th January he makes the payment of 3 lakhs. Okay, I will not say you to deposit again. I will tell you issue a notice. Because for me, that judgment speaks that when I issued a check, when I presented the check, the liability was there. But what will happen, suppose if I represent the check, even if I'm endorsing, for me, I am reading is that when the second time the check is being presented and dishonored, for me on that particular time, the legal debt was not there. It was just not there. Oh. This is the way I interpret, because I am an accused now. I have to say that way because implied contract or Indian Contract Act is very clear. Consensus ad idem has to be there. So what is happening is that when I am getting my second, that check bounced the second time, it shows that I had a talk with an accused, he made a payment of 3 lakhs. So there was a consensus ad idem. So the moment there was a consent, now you cannot backtrack and say, "Arey nahi, aapne to humko bola hi nahi tha." So that will become a defense. And definitely your legal debt cannot be, check amount should not be, more or less. SI. Now I'll tell you, that's why I refer to that judgment. Now what has happened that in Anita judgment, Supreme Court has made it very clear that the company has to be accused number 1. Okay. Right. Chhattisgarh High Court have said that the accused has to be represented separately. But just 2 days back, the Supreme Court is referring the matter to the larger being, saying that whether it is mandatory for a company to be made as an accused. Oh. So what is happening is that one view is not being stagnant. It is not being placed mandatory. It is just playing one A to B and B to C. So what will happen, I'll tell you, I'm assuming that way, that suppose if the Supreme Court passes a judgment, saying that, no, that is not mandatory. The cases which has been thrown away, they will file an appeal. They will do that.
Okay, so that was my query. Thank you. Thank you very much.
I hope the interpretation got that part, what you were thinking of.
is a notice mandatory because we are invoking a criminal law, and check bounce could be because of any reason, because there has to be mens rea before invoking criminal law. So intention cannot be proved unless there is a written notice. So is this notice mandatory, sir?
Yes, yes. That's why I use the word. See, the reason why section 138 is being termed as a criminal, but it is civil in nature. End of the day, 130 is only to recover the money. Okay. Yes. Now the logic behind is like this. See, if A and B, they are doing a business, out of 10, 7 to 8 traders, they don't have any intention to cheat anyone. What happens is market is bad. They have not received the amount. You have deposited check without informing them. So the law has made it very clear that the reason why the notice has to be issued is that, see, we are doing business. Now, if you expect me that a payment bounce ho gaya, maine intentionally kiya, don't take that assumption. You issue a notice to me. But even after me getting the notice, I am not making any response or payment. This is where the criminal angle comes. And
Then it becomes criminal. Yes, sir.
Now, that is the reason if you see any other provision, in there the notice is not required because there is no provision that you will make the payment. In fact, if you refer to Supreme Court's judgments just 3-4 days back, they made it very clear. Recovery of money does not attract criminal provisions 406, 420. This is the reason. Because end of the day, recovery of money is a civil part. So that's why this notice has become a part of 138 and definitely it is mandatory. It has to be issued because the whole base of 138 is notice. If no notice, no case. In fact, when you file a case, if you file a case complaint, it is a mandatory provision that you have to mention a paragraph saying that when the notice was issued, because if you don't mention it, the limitation period is not being counted.
Yes, in fact, there was one recent judgment of Bombay High Court in which it said that even when the 138 NI Act cannot be invoked, still the civil avenues of recovery are valid, and they can be resorted to for recovery.
Yes, it's like this.
Yes.
The biggest benefit of 138 is you file, suppose you have a claim of 20 lakhs, you file under 138 if you have a check. Simultaneously, you can file commercial suit, summary suit, civil suit, arbitration, MSME, NCLT.
Those avenues are open.
Yes, but because one is criminal, one is civil. You cannot opt for both civil. One criminal, one civil is applicable.
Okay. Because the intention is different. In civil, objective is to recover. In criminal, the objective is to punish the offender.
Yes. Because the punishment has been given. It's almost like a deterrent to you. And the basic part is that suppose if even if the accused is a company, the person who is a part to this transaction is personally liable.
Yes. Thank you so much.
421. That's fine. Thank you. I hope everything has been got into